Hi, I'm Jason Sullivan of Rathbone Group, and this is On Subrogation. I think we should have some Phantom of the Opera music for this video. Can't do it? Too expensive? Okay, fine. In this video, we're going to talk about phantom vehicles. You have a typical subrogation case land on your desk. Your insured was rear-ended. It seems like an open and shut case. You send the demand to the other carrier, and they deny. Why? They claim another phantom vehicle rear-ended them and pushed them into your insured. Therefore, they're not liable. What do? First thing I would do is try and vet that defense. What facts actually support it? So where do you start in trying to find that evidence? First, I'd ask your insured. Your insured may have information about what other vehicles were at the scene. Did anyone else stop? Did they see another vehicle? Did they feel more than one impact? All of that information can let you begin to look into whether or not it's likely there was another vehicle involved. Another place to look is the police report. Oftentimes on police reports and crash reports, it will indicate whether or not there's another vehicle and also the damage to the vehicles that are listed on the police report. Therefore, if there's a third vehicle listed and it's unknown, that officer likely got information at the scene that there was another vehicle involved. Also, if you look at the middle vehicle, your targeted tortfeasor, and you see the police report indicates both front end damage and rear end damage, well then maybe there was another vehicle involved. The police report will also usually take statements from the parties involved. And if that third vehicle is unknown, if that middle driver, your targeted tortfeasor, mentions that there was another driver and they were hit or pushed into your insured, the more likely that that is true. They're stating it at the fact. You know for sure this is not some defense or an idea someone came up with later after the fact to say why they're not at fault. If the police report is not very helpful, then the other thing you can do is ask the other carrier, that targeted tortfeasor's liability carrier, do they have any proof? If they adjusted their own collision claim, they may have front end and rear end damage and photographs that show that damage. You can then see, was that pre-existing damage or existing, and was that likely to have happened at that time of the incident that your subrogation claim arose? Frequently, though, if you're dealing with another carrier that is providing liability only, that other liability carrier may only be providing liability coverage and not collision coverage. And therefore, they're not going to have photos or estimates that show the status or condition of their insured vehicle, your targeted tortfeasor, at the time of the loss. If you're unsure about whether or not this phantom vehicle defense really exists and whether it's going to have merit, you then have the option to continue to pursue the case. Litigation may be an option, and in that case, you will have the burden of proof to show that the other party was at fault. If they raise the defense that somebody else hit them and pushed them into your insured, they're going to have the burden of proof to put forward evidence to show that by a preponderance of the evidence that the court or jury should find that there was another vehicle involved that either should share or have full liability for the damages ultimately sustained by your insured. Another option is if that liability carrier for that vehicle you're pursuing is a member of intercompany Arb, you can pursue the case through intercompany arbitration. Now, a lot of times I hear people say you can't go to Arb unless all people and all vehicles are covered by members of arbitration forums. And yes, that is generally true. The main difference being, in this case, you have one tortfeasor. There's only the one vehicle you've identified that rear-ended you. Now, they are blaming a phantom vehicle, and who knows whether or not they have liability insurance and whether they're a member of Arb, but you're not asserting a claim against that phantom vehicle. You're only asserting a claim against that vehicle that directly struck you, and as the dispute's between only you and that vehicle, and if both carriers are a member of arbitration, then arbitration forums will have jurisdiction. And they confirm that on their frequently asked questions section of their website, that in cases where a phantom vehicle is raised as a defense, arbitration forums will have jurisdiction, and it's up to the defending or responding party to implead the defense of a phantom vehicle. However, impleading that phantom vehicle does not change the jurisdiction. You can still pursue these claims, but you want to vet as much as you can at the beginning of the case by talking to your insured, reviewing the police report, any witnesses that might exist, as well as what the other carrier may be able to provide in terms of proof that their vehicle sustained damage. If there's no evidence that they were rear-ended and no one can point to this other vehicle, then you still may have a good chance of disproving their defense and can proceed and successfully pursue your subrogation claim. For On Subrogation, without Phantom of the Opera music, I'm Jason Sullivan, and that's the long and short of it.